All right, hey guys, it's Joel Williams of Williams Elleby here today with you, and I'm really excited to have my good friend Ed Piasta of Piasta Newbern and Walker here today. So we're going to go over a few things related to bad faith cases in Georgia. Some of you may know what a bad faith case is, some may not, but I'm going to tell you right now, Ed is one of the best lawyers when it comes to knowledge about bad faith cases, how they work, how lawyers should conduct themselves, what the duties of insurance companies are when they're dealing with claims that range from automobile wrecks to commercial disputes to anything and everything in between. So this is Ed, my friend, a great lawyer, and we're just going to have a conversation today that hopefully will be helpful to you if you're a lawyer in your practice, and if you are someone who's involved as a litigant in a bad faith case. Hopefully this will help you better understand how your lawyer is handling your case now, or what he or she should be doing, or maybe even some questions you should ask your lawyer to make sure they're doing the right thing. So, Ed, what I want to start out with really is I want to talk about situations where, say someone is injured and they need to make a personal injury claim against the at-fault party. You and I both know that most of the time what happens is the at-fault party is going to have an insurance company who steps in and kind of controls settlement talks, whether the case settles without a lawsuit, what happens when a lawsuit's filed, even so far as hiring an attorney to represent the at-fault person, right? So one of the biggest questions I have for you is, what duties, or what is the duty that an insurance company owes to its insured to help protect that they're insured from having an excess verdict, or having a verdict where it's larger than what their insurance policy will pay?
Well, it's essential, Joel. I appreciate it. Thank you so much for inviting me to talk with you. Joel's a great lawyer, great colleague for the last decade. I used to pound on his door when I was starting civil practice to learn about just everything about civil practice, and he was my guy who taught me. So I really appreciate sitting here with you today, and for you to come on over to be with us at Piasta Newbern Walker. The duties of an insurance company are really important to understand as a plaintiff's lawyer and as a claimant, because if you understand their duties, you understand your rights and what you can and can't do to enforce your rights when you're faced with a problem, such as your insurance company isn't doing what they should be doing. The fundamental seminal duty in Georgia, and it's similar in a lot of other states, is that the insurance company has to take the equal consideration of your interests, the insured's interests, as their own interests. They need to do a balancing test, and that needs to be level. The moment the insurance company's interests dip, where they consider the insured's interests less than their own interests, or put their own interests above the insured's interests, the insurance company has a problem. That's not the only responsibility that an insurance company has. They have a duty to defend most of the time. They have a duty to actually defend vigorously and investigate. So they can't just leave you hanging if you're found with a claim against you and whatnot. So they have a duty to defend. They have a duty to investigate. They have a duty to communicate all offers. They have a duty to communicate with you about the status of the claim. There's a lot of different duties, both contractual and through what we call the statutory and common law, that an insurance company has when you're facing a claim against you.
Yeah. And the statutory law, that's basically laws that the legislature passes and the governor signs into law, and they're statutes, right?
Absolutely. And just last week on I guess it was 2 weeks ago now, May 4th, the new bad faith law was created for motor vehicle accident cases in Georgia. Motor vehicle accident cases only, but on May 4th it was signed into law. It was House Bill 714. I think it's Act 203 or 204 now. But that governs pre-answer, so before a defendant answer demands in Georgia motor vehicle cases. And that's a statutory mechanism that controls it. Also, there's statutory mechanisms for first-party bad faith. That's when your own insurance company that you have coverage with, like life insurance policy, homeowners policy, and something bad happens, like, for example, if you were to die, God forbid, or if a loved one were to die, and the insurance company refuses to pay your life insurance policy, Well, that's actually a statutory bad faith. That's 33-4-6 OCGA, which is first party bad faith, that you would sue your own insurance company for failing to meet their contract and then try to get bad faith penalties, which is 50%. So that's statutory. It's like what the legislature exactly, what they come up with to govern things.
And the common law you mentioned, that's cases that have been litigated and have gone up to appellate courts, and then they have issued opinions that have established not judge-made law, but law in Georgia that usually is interpreting what the legislature passes, right? They're saying, okay, we know the legislature passed this and the governor signed it into law. Here's our job as the court is to interpret what that really means for litigants and for lawyers like you and me when we're trying to resolve disputes, right?
Oh, absolutely. In the common laws, it derives, and with third-party bad faith, that's when the insured is the person who did something that they may or may not be liable for, but probably did something they were liable for. Most of that law is the common law, which the seminal case that you and I cite one time a week is Southern General v. Holt. I've got the cite just to make sure we have it. It's 262 Georgia Supreme Court 267, 1992. So the case is almost 30 years old now, but it has not been overturned, and that's where the equal consideration of the insured's interest has their own interest balanced and tested.
It's probably been cited a million times in the state since 1992, man.
Oh, my goodness.
Crazy. Every day some lawyer cites that case, but anyway, we digress. Yeah, it's interesting to me when you were mentioning that part of the duty that the insurance company has is to give that equal consideration and a duty to defend, because I'm telling you, man, like as a law firm owner and a business owner, and as a father that has life insurance and all of that kind of stuff, and disability insurance and automobile insurance and commercial general liability insurance and workers' compensation insurance and insurance. Thankfully, I've never had a claim made against me, but chances are at some point in my life that something's going to happen and there may be a claim made against me. So if that happens to me, all I can think about is, all right, I've been paying for this insurance all this time. Now, what are you, insurance company, going to do to make sure that I don't lose my retirement, or I don't lose my house, or I don't lose all this other stuff because maybe I made a mistake, or maybe, what are you going to do for me to protect me, which in its simplest form, I think is the job of an insurance company, is to protect its insureds from having to pay out their own money for mistakes they made, right?
Absolutely. So when you buy insurance, you buy liability insurance to protect you against future claims. That's exactly what you're buying. You're buying your insurance company to be the professional to manage the claim process. Because ultimately what could happen is that if you get an excess verdict against you and you don't defend the case, you don't settle the case, and you go get a verdict against you, you're going to be liable for any excess amount of your insurance. So if you have like a $100,000 liability policy, but the verdict comes in at say $1 million for easy math, well, you're going to owe the $900,000 on top. So you've expected at that point the insurance company to do everything they can to resolve that claim for your contractually paid for benefit of $100,000 of liability insurance. So you expect them to defend you, expect them to communicate with you. You expect them to settle the claim if there's a valid offer and demand made for the policy limits.
Yep. All right, so one thing I want to talk about is something that we see play out in everyday practice, right? So if I have a client that comes to me and they have, say, let's just use a common example like a car wreck. They come to me, they say, hey, Joel, I've got $100,000 in medical bills because I had shoulder surgery and I've had all this rehab and blah, blah, blah. And then I find out that, let's say, the at-fault party only has $25,000 of liability insurance coverage, right? So most of the time, 99.9% of the time, the lawyer for the at-fault party, for the injured party, is going to give the insurance company for the at-fault party a chance to settle the case within those policy limits, right? So it brings you back to that equal consideration rule that you were talking about. So this is the opportunity for the insurance company to give equal consideration to the insured's interest and its own, right? So in a clear example like this, let's say I send the demand pre-suit to Allstate, say pay your $25,000 and we won't sue your insured. And let's say Allstate says, no, we're not going to do that. What happens?
So then what happens? Number one, the demand needs to be in proper form. So in a motor vehicle case, for it to be in proper form, make sure it complies with the statute. Make sure your lawyer out there, 91167.1, signed into law and revised 2 weeks ago. The demand's got to meet that statute. Assuming it meets the statute, it's in proper form, then what I do is I prosecute the case as the plaintiff's attorney. What we can do is essentially it's open limits from my perspective. If you send a proper demand that is in proper form and proper structure, in the insurance company like Allstate, typical dealer that we deal with a lot. And,
it's okay. You can say it.
We can say it.
They're bad. They're very hard to deal with.
They deny a lot of demands, and then you can get, it's open limits. You get to go try your case, and whatever the verdict is, then the insured, the person who is the defendant, actually becomes the plaintiff. And they sue their insurance company generally on 2 grounds, but lots of other grounds. You have bad faith, negligence. Sometimes an insurance company isn't necessarily acting in bad faith, but they're negligent in how they administer. They might be intentionally doing well or intentionally meaning well, but just do it badly. So there's bad faith and negligence, and then in the bad faith case where the defendant now becomes the plaintiff to sue their own insurance company, they're going to sue not only for the amount of the verdict to satisfy it. So let's say it's a $3 million verdict, $25,000 policy, but I think Joel's first verdict was like $3.4 million. And so let's just say that was a bad faith case. Not only can they collect the amount of the verdict of $3.4 million so they can satisfy that judgment and not go into bankruptcy, they also get to claim interest. They get to claim punitive damages. And punitive damages is a big risk for insurance companies when it comes to bad faith damages, because punitive damages in a bad faith action is with a specific intent to harm the financial interest of the insured. Yeah. When that happens, it's uncapped punitive damages. So the jury can award, generally in Georgia, punitive damages are $250,000 capped. So if you get $10 million in punitives, the judge writes it down to $250,000. But when it comes to bad faith cases, it's uncapped. So if you get $10 million in punitive damages, that's a $10 million in punitive damages fine assessed directly against the insurance company. So it's a high-risk game for the insurance company to not get demands right. Some insurance companies just don't care for business reasons, think that they fight just to fight. Other ones, I think, not all insurance companies are bad. Some actually meaningfully evaluate claims and administer claims as they deem fit. Doesn't mean they don't make mistakes, but some insurance companies just seem to fight more than others. But there's risk to them as long as you're willing to go get the verdict. If you go get the verdict or push them hard, we have a case right now on a $25,000 policy. Payment came in late. We bought a car over it to do a reconstruction on the case. Because why? Demand was good. It was not timely accepted, and we believe it's open limits, and we'll see where it goes. And whenever the courts open up again, and go from there.
Yeah, and speaking of that, from a lawyer's perspective, and this is not, there's different lawyers handle it different ways, and we're not here to try to tell you, what's the right way and the wrong. There's certain things that can be the wrong way if you don't follow the statute to the letter of the law, but there are some differences in sending these demands that lawyers will have. Some will put more stringent restrictions on how the insurance company can comply. Others are, in my view, more reasonable or allow the insurance company more wiggle room so that they don't have to bring over, a big bag of pennies and pay you $25,000. There's always extremists, just like politics, there's extremists on every side, but
there is. Usually
the right way to do it is somewhere in the middle, right? And so from a legal perspective, and this is more for lawyers and specifically plaintiffs' lawyers that would be sending these demands, what advice do you have for the proper way, outside of following the statute like you have to, but what advice do you have as far as handling and dealing with insurance companies that are being unreasonable, and laying the foundation in a professional way to increase the likelihood that you will eventually go get this big judgment and then be able to go back against the insurer for either negligence, like you were mentioning, or bad faith, and sometimes punitive damages?
I think it's a great question, Joel, and you and I write demands very, very similarly. We play it down the middle. I'm not unreasonable, and I'm not flimsy. I do believe in making specific terms in your demands. Make them clear. They should be clear and unequivocal what you're asking for, when you're asking for it, and why. So I think demands need to be clear. Look at it as a transaction. If you're making a $10 million demand on a case, you're making a $10 million transaction demand. That's a big deal. It's not something to be a form. You should take pride. We're all trial lawyers, but we're also transactional lawyers doing big transactions. So be specific and precise with your demands. Don't just knock out the form.
Be professional about it.
Be very professional about
Yeah.
it. I also think you need to look at your demands as exhibits in a future case. What is a future jury? How are they going to look at the terms that you put in there? Are they fair? Are they reasonable? Did the insurance company have an adequate opportunity to meet your demands in your terms? So if you say hop on your leg, well, I don't know if a future jury is going to like that or not. That's ultimately what's going to happen, because the bad faith case under every situation except for a first party situation is a second case. The jury is going to look at the demand in a second case.
Yep.
So general rules of thumb, I want them to be fair and reasonable demands, specific terms. Those are sliding scales for amounts. If it's a $25,000 demand, I don't care about the time limit. I want it to be as fast as allowed under the law. If it's a $25 million demand, well, the insurance company probably needs to have a little bit more time to investigate before writing you a check for $25 million.
And there may be multiple insurance companies involved when you get into amounts that are that high.
Absolutely. Like I remember you having a premises liability case that had multiple levels of insurance going into I say $godzillion, but it was excess of $10 million. Well, there's lots of different people that have to get in the room to talk about the demand. Well, you can't put a 5-day fuse on that demand and expect it actually to get accepted. There's other organizations that require, that we know require multiple levels of approval before they get a demand. So if you give them a 2-day demand, unless it's before a trial date when they should have somebody on the phone. But if it's just during discovery, that's kind of a meaningless demand in my perspective.
It puts you in a tough position too for that second case you were talking about, where you're trying to convince this jury that the insurance company acted unreasonably, where if you send a demand for $10 million and say you got to pay me in 5 days, well, the jury's probably going to look at it and say, well, you were being unreasonable, right? So you want, in my view, I always want to give this insurance company every opportunity that I can reasonably give them to pay the policy limits to a point, right? So we always want to maximize our client's recovery, and if the insurance company messes up and makes a mistake or doesn't comply with an original, very reasonable demand, that doesn't necessarily mean I'm going to send that same demand for the same amount, right? I may send another demand to them later, but it's probably going to be for a higher number, right? But I don't have a problem giving them multiple opportunities to try to settle the case, because I feel like the more opportunities you give them, the more reasonable you look if you do get that excess verdict, and then you do have to go back and prove the bad faith case or the negligence case. Do you agree with that, or do you have a different perspective?
In most cases, I couldn't agree more.
Mm-hmm.
I mean, there's some cases where the benefit of the deal is timing.
Yep.
So that, you get one opportunity and that's it because there's too low of limits. But imagine if you have a $10 million case and maybe one day it's worth $5 million, but you give them a demand for $10 million. Well, 5 and 10, when the insurance company rejects it, that's not necessarily bad faith.
Yeah.
But your case might get better over time, and bad faith is a retroactive review. So at the time you send the second demand, the jury gets to consider all the facts and circumstances the insurance company knew or should have known at the time the rejection is made. So if you have a pending motion that goes your way, or a pending motion that could go your way, that's sometimes a great time to send a demand. because the increased risk to the insurance company jumps because of the updated circumstances. And what happens when there's increased risk? They've got to communicate those offers to the insured. And if they're not, that's bad faith and it's negligence. They don't let the insured in on the demand and at least give input. Maybe the insured even in some companies have the ability to pay demands. And you don't give them the opportunity to settle the claim. That really sets up a bad faith later on. General rule, send as many demands as you can that are in the interests of your client. And ultimately be thinking about that case 2 years down the road. Some cases, if there's low limits and there's massive damages, they get one time and one time only.
Absolutely.
But in a lot of cases, when you have higher limits and more movement on what the potential value is, then I think multiple demands makes a lot of sense, and is exactly what we do here.
Yep. Okay, so that reminds me of one thing. Speaking of communication between the insurance company and the insured, I've always found it interesting. I mean, honestly, I've handled 2 or 3 defense cases in my life, so it's not like I'm some expert on defending lawsuits, because I'm usually on the other end of it. But I've always found it interesting that when someone has a claim brought against them and it goes into litigation, sometimes before it goes into litigation, but almost always after it goes into litigation, the insurance company is going to hire a defense lawyer to defend the case. Okay? Nothing in the world wrong with that as part of the insurance contract that you pay for every time you pay your insurance premiums. But I've always thought that it's interesting, and how does this really play out behind the scenes if I've got that Allstate case and I've got $100,000 in damages, there's $25,000 of coverage, Allstate blew it, and then I sue their insured, and then Allstate hires a defense lawyer to defend their insured, and Allstate's paying that defense lawyer to defend their insured. But in all likelihood, we're about to go get a verdict for much more than the policy limits, which means that Allstate's interest is not aligned with its insured, but Allstate is paying for the attorney to defend the insured. Like, it seems like there's an inherent conflict there, but for some reason legally there's not, right? So help me understand like how this works. Like if you're in the defense lawyer's position, and maybe there's a defense lawyer that's been in this position before watching this video, you know, what advice do you have? Like, because certainly the duty is to the insured, right? To the client.
Well, exactly. So the insurance company hires you a lawyer that they pay for. That attorney's duty is to the insured, not the insured. All the duties and responsibilities in the Georgia Rules of Professional Responsibility are to the client, who's the person facing the lawsuit, not the insurance company. The insurance company pays it, pays the bills, and pays the experts, but they aren't the ones who the attorney owes a duty to. The attorney owes a duty to the client. In fact, there's a state bar advisory opinion on this, 86.4. In the case of a settlement demand, the attorney for the insured has a duty to communicate all settlement demands to the insured. And they also have a duty to advise the insured, not just that a settlement demand was made under advisory opinion 86.4, they also have a duty to tell them that if the insurance company makes a bad faith refusal to settle the claim, that they can sue the insurance company. So the State Bar of Georgia actually tells defense attorneys, you have to tell the insured exactly what they're facing. So we actually cite that in demands, the advisory opinion. I know you do too, Joel. 86.4, that's the duty on settlement demands. So a lot of defense lawyers are really good at it. I think they balance it. They understand their role. I've been one of those lawyers. When I was on active duty in the military, I started off as a prosecutor, but then I was a criminal defense attorney in the military, paid for by the U.S. government to beat the U.S. government during trial. My duty were to my clients. My money came from the United States, the Treasury, but I fought like heck for my clients facing conviction, so I get that. And there's a lot of defense lawyers in Atlanta that really understand their duties. There are some that don't. And so you really, need to make sure you educate those lawyers what their duties are. You'd be surprised how many defense lawyers do not communicate settlement offers to their clients. That's their fundamental duty. For plaintiffs' lawyers, if you don't send an offer to a client, you're actually failing your duty to communicate.
It's unfathomable. And I know it happens. I know it happens. Excuse me. But just the thought of not relaying a settlement offer to a client blows my mind.
Yes.
It just blows my mind.
Completely.
But yeah, so honestly, man, if you're a defense lawyer and 90% of your business comes from an insurance company, I feel for you, man. I really do, because as a plaintiff's lawyer, I get it when you're struggling between, all right, I've got partners to answer to. I've got, if you're an associate, I've got senior partners to answer to. And if you're a partner level, you're answering to your own partners and trying to keep profitability up. So you're beholden to your client or the insurance company to some extent. But your ethical legal duty is to the person who you have to defend. I get it, man. I really do, and it's probably one of the main reasons that I'm not a defense lawyer, because I don't want to be in that position. But I would just highly, highly encourage anybody that's watching this, don't ever forget what your role is as an attorney. Your role as an attorney is to help people. And when you're helping people, sometimes that means that you have to help a person, even if somebody else is paying the bill. Because your client is always more important than the dollars that you're getting paid to prosecute the case. And so, like you said, most attorneys are very good at that, but I can see how it'd be very easy to lose sight of that duty. So if I had any one piece of advice to give to especially a younger lawyer coming out of law school who gets a job at a defense firm that most of their work comes from insurance companies, just never forget what your job is, what your ethical duty is, and why you became a lawyer, and it's to help people regardless of whether you're prosecuting a case for them or whether you're defending them against a claim that's been brought against them. It's all about the client, right? And if you find yourself in a firm that encourages you to put the profitability of the insurance company ahead of the person that you're trying to defend, get the heck out. Get the heck out. Come talk to somebody like me or Ed, and I promise you, we got open doors for that kind of stuff, and we will be more than happy to talk to you to help you find a position somewhere, whether it's with our firm or somebody else's firm, where you can actually be the lawyer that you're supposed to be. So that's the biggest piece of advice that I would have for younger attorneys. So what about you, Ed? Like if you were giving a piece of advice to, say, an attorney that maybe has $500,000 or $250,000 of law student loans, and they feel like they have to be stuck in this high-paying position, but they have this little devil on their shoulder saying, this is a bad spot to be in, right? You're in a tough spot, and your firm is encouraging you to act unethically. I mean, what would you say to somebody like that? And as far as encouraging advice would go.
There's a mentor of mine has told me there's two questions every lawyer should ask at every stage of your career. What type of law do I want to practice, and who do I want to practice it with? And those are two questions that Joel and I, we work and we're two different firms, but we're all friends, and we all believe in our ethics and our morals and our work ethic, and we do cases the right way, and we know our role in the system. I would rather, if we do a case right, we win a lot, but we do lose cases. But I always respect my place in the system. My place is not to call the balls or strikes. That's the judge and the jury. So think about where you fit in your career. Just because you got a lot of loans, I wouldn't necessarily make that a deterrent on what you do with your life, because you choose now. And Joel, when I met you over a decade ago, my goodness, to think where we're at today, with our careers was unfathomable at that point. So time goes quickly, but what you do with your time is so important. It's how you invest in yourself, how you invest in others, and over time your career becomes much more and more developed and comprehensive. But if you stay at a place in where you think people are being unethical, or not doing it the right way, or not putting your clients first, and you're like, in that insurance type driven where the insurance company makes the calls, not the best of the client. Not all firms are that way. I really do believe there's a lot of good defense firms, and most of them are, but there are some bad ones. There's no question about it, and I'm not afraid to say it. But if you're in one of those situations where you're at a firm that is not following the ethics and is doing it wrong, get out. Just get out. There are so many opportunities out there, whether it's to be a personal injury lawyer or a trial attorney or a transactions lawyer or a government lawyer or going into business. My goodness, there's so many different things you can do.
Go run to be a judge.
Go run to be a judge.
Whatever, just there's stuff you need to do so that you can put your head on your pillow at night and sleep soundly and be the person, man, woman, husband, wife, brother, sister, whatever, that you need to be happy. So really that's what it's about. And most of us got into this to help people. So do what you can to help other people without sacrificing yourself. And so really what I want to do, and I know this video is getting a little longer than most of them that we do, so I kind of want to wrap it up, but before we go, if there's one piece of advice that you could give to a person who needs to bring a personal injury claim against someone else where there may be limited insurance coverage, but the damages are very high, like catastrophic injuries, what piece of advice would you give to that person prior to them hiring a lawyer?
My advice would be investigate lawyers. I really do believe if it's a motor vehicle claim, you should have a lawyer write the demand, because if it doesn't meet the elements, it's as if you didn't write it in the first place. But that person should really investigate what lawyers they want to hire, who's going to protect their interests, who's going to give them advice. Just because there's limited insurance, if the person's rich or the company's rich and has assets, it doesn't matter. If Walmart didn't have any insurance, they have insurance, but if they didn't have any insurance, who cares? The company makes billions of dollars, billions and billions and billions of dollars. So there's not really a concern. So I really think, regardless, people should, if you're facing an uphill battle, you should investigate who your lawyer is going to be, in whether it's low limits or high limits. Do it right, because it's a high stakes game for you. The civil justice system, unfortunately, can't put your physical ability back to where you were before your tragic incident, but it can compensate you and get you the medical treatment and get your medical bills paid and get you pain and suffering damages. So I would really have a comprehensive look before making any decisions.
Yeah,
that's my view.
That's awesome. Yeah, and I think if I had one piece of advice to give to anyone who's in that situation, and this sort of applies to anyone that needs to bring a claim anyway, it's okay to make your claim about you, because it really is about you. It's your rights, it's your loss, it's not the lawyer's rights or losses. So when you are looking for an attorney, personally, I would recommend staying away from attorneys that advertise in such a way to try to make themselves look like heroes, because we're not heroes. I mean, some of our clients that have good results may call us that, but we're not. We're lawyers, and that's our job, is to help people. So it's not about this big verdict or this catchy ad or something like that to show you what a Billy badass I am. It's about how that lawyer can help you, and are they willing to help you, or are they going to spend more time taking photo shoots for billboards or whatever, or are they going to sit down and try to give you information like we're giving you today? So I would stay away from lawyers whose advertisements are all about them, and find lawyers, like Ed was saying, research them, and then sit down, pick out 3 firms. maybe you pick out my firm, Williams Elleby, or you pick out Ed's firm, and maybe you pick out, I've got, Shiver Hamilton, Jeff Shiver and Alan Hamilton are good friends of mine. Pick any good firms and go around and meet with them. Go sit down with me in a room. Go sit down with Ed in a room. Go sit down with some other lawyer in a room and decide for yourself who you think is the best fit for your case. Because I'll tell you right now, if you called me about a workers' compensation case where you're injured, I'm not the best fit. I'm not going to be the best fit. Or you may call about a tractor-trailer case that happens on I-75, and that's right down my alley, but maybe our personalities don't mesh, and I'm not the best fit for your case, right? So take the time, invest in yourself, and interview the lawyers and see who you believe is going to put the time and the effort into your case, and that actually has the expertise and the fortitude to follow your case all the way through trial. Because like Ed said, if there's limited resources or limited insurance limits and catastrophic injuries, you may be going through 2 different sets of trial to get maximum compensation. Okay, so do your research and invest in yourself and make sure that you find a lawyer that's willing to invest his or her time, effort, resources, money, and emotional support into you. And I think you can't go wrong. So that's really all I've got today. If you're a lawyer, if you're a person who needs a lawyer, if you'd like to reach out to my firm, Williams Elleby, you can do it by calling 833-LEGAL-GA. Ed's firm, Piasta Newbern and Walker. What's the phone number here?
404-996-1296.
There you go. So, and if you don't like either one of us, you can call us up and we'll give you the names of some good lawyers that you can call that would be the best fit for your case. So thank you so much for spending time with us today.
Thank you.
And we hope it's been helpful. If you have any additional questions, if you're watching this on the YouTube channel, feel free to post those questions down in the comment section below. We'll do our best to answer them. And if you think this is useful, or you've got an attorney that's handling a bad faith case and you don't think they're doing it right, share it with them. Let them see it. Maybe we can help them out so that they can help you. So appreciate your time today. And yeah, that's it. Thank you, Ed. Appreciate it.
Appreciate it, Joel. Thank you.